All right, we're back. Welcome back. Our next panel is on managing internal investigations and advanced government defense. And I think it's going to be an interesting one. They've got an interesting approach to this panel that should be different and pretty cool. But let me first introduce our moderator, Dixie Johnson. Dixie is a partner at Spalding and the firm's deputy practice group leader for government matters. Some of Dixie's best work is done behind the scenes. Since joining King & Spalding in 2014, the government has closed almost 40 investigations without charging Dixie's clients. Impressive. Also, one of the first lawyers to get a call when board committees need to investigate accounting and disclosure-related whistleblower allegations. So, Dixie, as always, it's great to see you. Welcome.
Good to see you too, Bruce. Thank you.
Next, we have Bill Baker, a partner at Latham and Watkins. Bill, of course, was an associate director in the SEC's enforcement division, where he worked for 15 years. Among the cases that Bill worked on, of course, was the WorldCom case, one of the largest financial frauds in history. Bill, it's always great to see you. Welcome. I'm very pleased to introduce Anita Bandy from the SEC. She is now an associate director in that division, in the enforcement division, that is supervising 40 attorneys and other staff. It's always a pleasure to welcome Anita, and thanks for being here.
Thanks, Bruce. Always a pleasure.
And finally, let me introduce my longtime pal, Phil Khinda, a partner at Cadwalader and also a veteran of the SEC's enforcement division. One of the top advisors anywhere to public companies and corporate boards when it comes to things such as internal investigations. And Phil was the one who led the huge investigation in the CalPERS special review that dealt with pay-to-play and public corruption. One extraordinary item from Phil's bio, which I've said before, and it continues to be true, no corporation or individual that he's represented from the outset of an investigation has ever been sued by the SEC or indicted. Nice job, Phil. Phil, thanks for joining us.
My pleasure. My pleasure. Thanks, Bruce.
All right. Dixie, let me turn it back over to you.
Terrific. We're going to have a great time today, and I'll tell you what the plan is. But first, let me turn it over to Anita for that disclaimer I know everybody's waiting for.
Sure. Thanks, Dixie. Thanks so much for moderating, and thanks for Bruce for organizing this great conference. Really excited to be here. And the disclaimer that Dixie was referring to is that, even though we're in role play mode today, dealing with a hypothetical simulation, any views that I express are my own and not necessarily reflective of the commission, staff, or any commissioner. Thank you.
Great. It's wonderful to have you here. So we're going to do some role playing here. We all have extensive experience in various aspects of corporate internal investigations or company internal investigations. And so we're going to play different roles to help you see how things and feel how things occur over time. We'll do this in 3 different segments: the beginning, and then alternative 1 scenario outcome, and then alternative 2 scenario outcome. And each one will be about 10 minutes. Anita is going to represent all of the SEC staff. No matter what the level of the question may come from, she's going to be asking it of us. And so she will be leading a lot of the questioning. Normally in these panels, we put the staff person on the spot, and in this one, she's going to put us on the spot. So that's what we're going to begin here. And it'll be a typical overview of what the staff would want to know as a situation unfolds. Phil is going to be serving as general counsel to our company and the company's lead outside company counsel. He'll be either one or both at the same time, but he'll be the one answering for and representing the company as an entity. Bill is going to be board counsel or audit committee counsel, depending on where we are in the scenario. And he will be evaluating things from a more independent perspective, although I'm sure Anita has some questions for him about independence. And I'm going to kind of be a field player. I will be either the CFO's counsel or the outside auditor's counsel, whatever's kind of needed in the moment as we work our way through the scenario. So let me outline the beginning scenario. The company has received an anonymous internal hotline report saying that someone in the finance division is manipulating financial results in order to communicate false information to the public. The anonymous allegation is generic. It does not identify who allegedly is doing this, what data is being manipulated, or what time periods this occurred during. Phil, who's the company's regular counsel, inside and outside counsel, has been asked to handle this situation. He knows that there have been other recent situations in corporate America, this is true, where generic hotline reports like this were not real and instead were revealed to be part of an alleged international research project. So Phil does some preliminary work. He checks with corporate counsel, the entity which outed the prior situations, in case you're curious about those. Phil has determined that this message does not appear to have been sent to multiple parties, and despite it looking generic, is something the company's own policies require follow-up for. So Anita, I'm going to turn this over to you to start off by asking any of us the questions you want to ask when you first hear that this investigation is underway, or this incident has happened at the company and the company is dealing with it.
Sure. Thanks, Dixie. So I think I'm going to assume that the first phone call that the staff gets is from Bill, introducing himself to me as counsel that the independent counsel that the audit committee has retained. And in that capacity, I think, I'd want to keep an open mind. And for Bill, I think my questions for you would be, what atmosphere is independent counsel creating that inspires trust and confidence in terms of the next steps that the company plans to take. And I think that being an honest broker and approaching us with a plan that allows us to have confidence and allows us to believe that the company is approaching this with objectivity in terms of going where the facts and evidence take them, will ultimately guide the staff's decision in terms of whether they're going to wait to hear back from you, Bill, in terms of what you find. Obviously, there's no guarantee that the staff is going to, that we're going to hold our investigation and our processes in abeyance, but, approaching us with a high degree of credibility up front, I would say, increases the chances that we're not going to get in your way and that we will be open-minded in terms of hearing what you report back to us. So with that macro point in mind, I'm going more to specifics, Bill. I think, my first question would be, what is your work plan? What's the scope of the investigation? What departments do you plan to focus on? Are you going to employ or retain a forensic accountant? And to, what are the steps that are being undertaken to really understand the scope of the review and what's not being reviewed? What are decisions being made in terms of scoping? So I think scope is one issue, and then alongside what usually takes place at a preliminary stage of an investigation, we'd want to understand, what document retention and preservation efforts are being undertaken. What custodians have been identified. Hard copy documents, voice recordings, phones, laptops. Document preservation as it relates to the financial control function. Support for journal entries, walk us through, how documents and all sources of information are being preserved in the financial aspect of the company's dealings. And then, I think going a little further in terms of witnesses, preliminarily, we would want to know from Bill, what witnesses have been identified, are any employees implicated at this point, and have there been any personnel decisions that have been made? To the extent that the internal investigation emanated from an anonymous source who potentially could be a whistleblower, I think, Bill, you're going to need to be very mindful of making sure that in the course of conducting an internal investigation, you're not tripping over whistleblower statutes such as 21F17, and that the company is not inadvertently taking action that creates a record that the company is actually impeding a whistleblower from coming forward to the commission or is taking retaliatory action. So I think that's an issue to be mindful of. And I'd say, it looks like the company has chosen to retain independent counsel. Just a quick word on that. It completely up to the company whether it chooses to retain independent counsel at the direction of the audit committee, or whether the internal investigation would be conducted by company counsel such as Phil. That's not a decision we typically weigh in on. But we will, however, look very closely in terms of whether the company is being transparent, forthcoming, objective, and to the extent it's company counsel, if Phil steps in, that Phil's judgment is not being clouded by prior history with the company. So again, it's all about establishing credibility with the staff and being an honest broker.
Bill, if you want, I can set the table and then pass it to you. Up to you.
I think I can handle these questions, Phil, but thanks. So all good questions, and let's just assume for the moment that enough work has been done at this point that we really feel it's appropriate to notify the commission. I think less so today than maybe in the past. There's been a tendency to run to the commission or to law enforcement or to make premature public disclosure before you know enough to say anything. But let's assume that Phil has done, when it first came in, Phil got internal audit involved, and in addition to deciding that it was sufficient, there was sufficient credibility to the complaint that more work was done. Enough has been done to elevate this to the audit committee, and for the audit committee to determine that they wanted to retain independent counsel. And since the matter involves financial statement issues, almost certainly you're going to hire a forensic firm to help not only with financial analysis and accounting analysis, but also with the gathering of electronic data and the analysis of that as well. And we talk about independence a lot. Competence, in my view, is just as important, maybe even more important than independence. And so if the board isn't asking those questions about, how often have you done this before? What have your experience been? And Anita, I think, is right that the staff generally, not always, but generally will defer to the decisions of the company and the board. Those in the audit committee, by its nature, is independent, by rule is independent. And so I think it's less important whether the law firm advising the audit committee has ever done work for the committee before or has some prior relationship that while not rising to the level of a legal conflict or an ethical conflict, might raise some optical issues. But at the end of the day, it's the audit committee that is the trier of fact, if you will, during the course of the investigation, and makes the decision about who's gonna and who should conduct that investigation and what the facts developed in the investigation show, what you're going to present to the commission. One thing that Anita didn't touch on is any discussion about what you're going to get at the end of the investigation if you rev up the massive Latham and Watkins team and whether it's Ancora or Alex Partners or FTI or any of the many great forensic firms that are out there. You start that process, what you're going to get at the end of that. And maybe we'll talk a little bit about that in a moment. But the last thing I'd say is this is an important discussion, but how do you define the scope of the investigation? Because time is the enemy of the company in a situation like this. If you're notifying the SEC, it's likely there's going to be a public disclosure. If there's no public disclosure initially, it's likely that information is going to get out there. And having that overhang can be extraordinarily debilitating in a wide variety of ways. I mean, reputationally, your ability to raise money, and just the notion that people are at risk within the company, that all can be a tremendous drag on the company. So you want to be able to credibly define the scope. More issues mean more witnesses, more e-data, and more problems. And you know that the auditors, your client, the audit committee, and the commission are all going to be saying, when is this going to be done? When are you reporting to us? And finally, let me just touch on the scope issue and just a moment longer and note that in the most successful matters that I've been in, if you could educate the staff early on about scope, who the likely witnesses are going to be, who the custodians are going to be, what your search terms are going to be, and they will be careful to tell you it's all on you, that's all your responsibility. But this is frankly where the remote nature of the last 18 months it is extremely hard. You can't get in the room with people and read the room and see how they're reacting to what they're telling you. But that to me is also extraordinarily important. So that's sort of the dialogue that I'd want to have with the client, with the company, and with the SEC. Phil, I'm sure I missed some things I should be talking with the company about, and maybe you can help me with that.
Well, let's begin at the beginning because we're a little ahead of ourselves. To my mind, where this begins is within the company. We get a complaint, we assess its credibility, and it's all about reasonableness and line drawing. We wade in and wade in and wade in until we decide this thing is real and we are going to commit resources to it. I agree with you. Independence is a proxy for something more important, and that's integrity. It's what I would say to Anita as I'm doing this, which is watch how I do it. Tell me where I pulled our punches. And so I would decide, do we need to hand this off to the board? Even though I know I could do it. So, Bruce, our host, asked us to do these videos on one big thing. And we were given a minute each. I didn't do one, but I don't need a minute. I'm going to tell you the one thing right now. If there's one thing you remember from this whole day, it's this. Always think of the very end at the very beginning. Always. And so if you're defending a company, if it's litigation, how do we get to checkmate? What's our end game? That informs our opening moves. The trickier thing is if it's an investigation, right? The end game isn't a particular result, although there are people who conduct investigations like that, and you know who you are. But it's instead, how do we develop a process that will stand the test of time? An investigation that 10 years later still stands up. Not one of these that you read about in the press where, findings are made exonerating someone, at least in part, with lots of qualifications, and a month later, right, the head person's resigning. Or emails blow back onto a different entity and then come back on the main subject. And so the first thing we want to do is think about what's a process that will get us to the end. And so what we would be doing as company counsel is bringing this over to the board, what's the right committee of the board? In this case, it's the audit committee, deciding on a disclosure strategy, and it's orchestrating it entirely from the company. Now, even though I'm turning this over as company counsel to Bill and putting this in his good hands, I still remain the hub. I'm the one talking to everyone. I will be talking to Anita. I'll be talking to Bill. I'll be talking to Dixie and her 5 counterparts who have the various officers, because we'll set up shadow counsel. I will represent the company, and as best I can represent the people whose interests appear to be aligned for now. But to protect both their interest and the company's, I will always have someone behind the scenes, either as pool counsel or dedicated shadow counsel to each of them. So if there is a divergence, then separate counsel is ready to go. And managing all of that gives you an advantage. If I'm the hub, I know more than anyone. And I'm in a position then, not to shade it, not to slant it, that's not how this is done, but instead to inform Bill and to inform Anita. Because I want Bill's report or board presentation to be fantastic. I want it to be persuasive, I want it to be definitive, and I want it to represent an ending to this thing. And so we're not just going to sit back and say the documents are in the back, here are the keys. We will think of everything, do everything again, having thought at the end at the beginning, so that in any meeting I'm in, though I will try not to show it, whether with Bill or Anita, I know the answers to questions they haven't even thought of yet. And that's the way we go about it.
Yeah,
You not sitting back. You felt you not sitting back is a good segue for me, because I think I'd want to also have a line of questioning with you. Depending on the timing of the conduct, I think I'd want to ask you whether the company, in the spirit of cooperation, would be willing to give us a tolling agreement, so that there is more flexibility in whatever plan Bill proposes for an independent investigation. And there are requests that I think we could make of you. There's no guarantees that, again, the staff is going to hold our investigative process in abeyance, because the worst outcome for us is that the investigation is done, but it's limited in nature, it's limited in scope, and it doesn't ultimately help to accelerate and give us the information that we need to execute on our mission. So in order to manage to that risk, which has happened many times, depending on which counsel is doing an investigation and who the client is, we may still have requests of Phil. We may want Phil to give us policies and procedures. We may want Phil to give us attorney proffers on control functions that are at issue, how journal entries are kept, how the hotline process is managed. So there's a number of things simultaneously that we could request the company respond while Bill undertakes his internal investigation. And that way, both sides are sort of protecting the interests in truth finding. And then there's certain other things we could do. We could do interrogatory type requests on limited and discrete issues that we need to understand. We may engage the auditor, and we're going to get to that in a minute. I know, Dixie, you're going to be playing the counsel to the auditor. But how much of a simultaneous investigative process we engage in depends on not just the trust that's inspired, but also even in the best case scenario, sometimes we do need to move forward. And that includes, situations where there are statute of limitations issues, perhaps with former employees, that even if the company, in the spirit of cooperation, gives us a tolling agreement, isn't good enough for us. There could be a situation where we're coordinating with criminal authorities or a foreign regulator. There may be, a whistleblower that reaches out to us, and we have a duty to follow that lead and see where that takes us. But I think that where possible, where these some of these overriding issues don't come up, I think, and that trust is inspired, and Bill and Phil present a plan that inspires a degree of objectivity and confidence, I think we are flexible. We want to be flexible and be aligned in our interests in getting to the truth of what happened.
Let me move to the next couple of scenarios, because as you can already tell, there are so many issues embedded in internal investigations that we could spend more than a day, I'm sure, running each of them to ground. And that typically does happen. There's a lot of interaction on these over time. Let's think about two different scenarios, and I'm going to introduce both of them at the same time. And then we can pop back and forth in the two scenarios, because I think it will be easier to deal with than going through one and then stopping and turning to the other. So the first scenario is the investigation is complete, Bill has finished, the audit committee has concluded that no fraud occurred, But the company's processes for finalizing quarterly financial results and reporting them to the public should be improved. And that's the kind of finding that sometimes happens in internal investigations. So that's scenario one. Scenario two is we get to the end of the investigation, Bill completes his investigation, the audit committee concludes that a restatement is necessary due to errors in the financial statements. But the evidence is insufficient to conclude that fraud occurred. And the CFO, my client, has left the company with a severance package. So, Anita, going from one scenario to the other, whichever one you prefer, can you kind of play out some of the staff reactions and who you want to hear from? I'm sure you want to hear from both Phil and Bill, and hopefully you don't need to hear from me.
Yeah, so I think we'd want to understand, Bill, from you, what you did. Walk us through exactly what you did. Give us the facts. This is not the time to whitewash or posture or really make arguments. Give us the facts. And I think it's important to understand that, there's the companies or independent counsel is taking a gamble if they're doing too much posturing and our arguments at this stage, because if they turn out to be wrong, I think it could impact credibility of the company's credibility, the audit committee's credibility, and counsel's credibility. So I think at this stage we want the facts. What documents did you collect? How did you identify them? What search terms? What were the time periods? What's the reasoning for where you landed. And so we want to understand what you looked at, what you didn't look at. We want to understand financial implications. What were the problems? What's the process for finalizing the quarterly financial results? Describe the impact and problems on any GAAP or non-GAAP metrics reported by the company. How is the company looking at materiality, both from a quantitative and qualitative perspective? Have the auditors been aware of the findings, and do the auditors agree? What's the level of engagement with not just the company's outside auditors, but also, what did the forensic auditors look at? Do the forensic auditors agree? What was within the forensic specialist scope of review, and what was excluded? And so I think that it's very important for us to really understand how the determination was made that no fraud occurred. Then with regard to witnesses, we would want to know, who you interviewed, how many times. Were these witnesses represented by separate counsel at this stage? Was it all, done more with company counsel or Bill? Did you use any documents? And would the company be willing to provide summaries in a way that doesn't implicate, obviously, work product or privilege or issues under Herrera? We'd want to know if any witnesses refused to cooperate. Did any witnesses corroborate each other? So those are all questions that I think we would want to know with regard to witnesses. And then I think on the issue of remediation, we'd want to know what remedial steps, if any, have been undertaken at this stage. Even if no fraud was uncovered, it looks like there could be controls deficiencies and weaknesses. And so we would want to know, is the company implementing any remedial measures? And did Bill recommend the company to implement any procedures or steps that the company has refused to do? And we'd want to understand the reasoning there. And then alongside those kinds of controls assessments, we'd want to understand if there were any personnel decisions that have been made at this stage. And if personnel decisions have been made, the staff's not going to weigh in on that. We're going to defer to the judgment of the board to determine what's in the best interest of the company. But we have a right to know what the company's thinking by way of personnel steps. And to the extent that personnel steps are being contemplated, we may want to ask the company to see if there's an opportunity there for the staff to take testimony or interview of a witness before those personnel actions are taken, because that could change the posture of the type of information we're able to elicit. So I think those are the issues that I would want to raise with Bill. With regard to Phil, I can come back to Phil, but one question that I would really want to understand is on conflicts, making sure that the company has vetted conflicts of interest appropriately. Again, this is something we're not going to weigh in on. We're going to defer. We're going to assume that counsel is adhering to their state ethical obligations in terms of vetting conflict issues carefully. But to the extent that multiple witnesses that have some appearance of conflict are all being represented by company counsel, and that somehow adversely impacts the type of statements witnesses are making. Everybody has collective amnesia, or witnesses are taking positions that are just completely contrary to documents, and there is an appearance of conflict, and those judgment calls aren't being made appropriately. I think it's completely fair for the staff under Seaboard to assess whether the company, who operates through its employees, has created an atmosphere that's conducive to candor. And certainly if the company's inability to vet conflicts appropriately prevents a witness from putting themselves in a better position, especially in light of our highly successful cooperation program, then that's something that could have serious consequences, and that's something we would weigh in terms of the spectrum of cooperation.
Well, a lot there. Let me unpack it from the side of audit committee counsel, and then I'll let Phil respond on behalf of the company side. As you approach this, and we talked a moment ago about the fact that we're going to try and reach agreement with the staff on scope. We're going to try and reach agreement with the staff prior to starting the investigation on custodians and witnesses, and so that when the investigation is done, there won't be any surprises at that end of the when you go in and report. I think it's also important to remember that the primary purpose of the investigation is not to satisfy the SEC, which is very important, but is to make sure to determine, are the company's prior disclosures accurate? Are the company's prior financial statements accurate and comply with GAAP in all material respects? And if they don't, what are the accounting determinative facts that you need to know so that if you have to go back and restate, that restatement is accurate and complete, you do it once, and that the company, you can correct any prior misstatements in the company's public statements, public disclosures. So that's the primary purpose of the investigation. In general, and every investigation is different. In general, my belief is the best way to find the facts is to make sure that witnesses are adequately prepared, so that that you wouldn't tell them what the questions are going to be in advance, but you certainly make documents available to them, and so they're not seeing that stuff for the first time in an interview, but in fact, you're going to get their best recollection and the best understand of what happens. If someone wants a lawyer, I don't think, as audit committee counsel, I'm in the business of telling them in an interview that could have significant repercussions for their personal liability and professional success, that they can't have a lawyer in that setting. That tends to slow an investigation down, but it also, in some instances, may speed the investigation up. If there's competent counsel on the other side who helps them prepare, that may be a net plus. However that ends up, I'm going to make sure that the staff is aware that that's the approach that we're taking. We're certainly going to tell them if someone's not cooperating, and we'll consider, we'll make recommendations to the audit committee, and The great thing about having an audit committee as a client is it's a rare battle that management is going to win with the audit committee. So you have the ability to significantly influence. If people aren't cooperating, you have to ask why and whether or not that means they can continue to function in the role that they may have had previously or continue to be an employee of the company at all. So hopefully, when I go to report, there'll be no surprises about scope. There'll be no surprises about the process that we followed, which leads to, I think, one of the most difficult aspects, which is the form and content of providing information to the staff. I think occasionally counsel will tumble off of this over this because they want to impress the staff with the breadth of their investigation and all the work that they did, and the 15 extraneous witnesses that they talked to. I tend to try and move in the other direction, which is it's tough to present the results of an investigation in 1, 2, 3, 4 hour sessions. Sometimes you want to break it up, but however you do it, you want to focus on, I think, the most material aspects, and then let the staff ask the questions that they want to ask, and if they need additional information. The form that you put that in, a lot of people like to use slides and a detailed presentation in that regard. If there's a parallel securities class action or derivative litigation, I tend to be very careful in that regard. I think it's just generally better to use original documents and to walk them through in that fashion. It's challenging because even if you have a cooperation agreement with the staff, the case law is not great on sharing information. And candidly, the staff is not always entirely consistent in the approach that they're going to take once you've provided that information to you. I know Phil is chomping at the bit because he wants to talk about how he's going to protect the company in this situation.
Well, these all sound like stories born of bad breakups. And so instead, what I'm going to say is, look, this begins and ends with the company. And if you're at the company, you want the investigation to be a triumph. We want to be done. We're happy to restate. I'm happy that there's no fraud, right? It makes the civil litigation go away. But what I don't want to do is close down the committee's investigation and 6 months later realize the answer was something else. So there will be the part where Bill and I walk around the block and I say to him, look, even though the commission can't prove it, so-and-so, maybe one of Dixie's clients, something's not right there, okay? And even though the government may not be able to bring action, there are a lot of levers I can push, right? And there are different people, as I like to say, we're happy to wander in the desert until everyone's consumed, because when we go forward, everything's going to be right. And so I want the investigation to be a triumph, and it'll fall on me as company counsel. Look, there's two ways this can go, and Dixie knows exactly how to do this. There's the wrong way in which, now Dixie would never do this, but this is where counsel for some individual, usually a marginal individual, is screaming about how they're misunderstood, screaming about how the documents show just the opposite, and the government's got it all wrong. Now, in my experience, the government does make mistakes sometimes. They're almost never all wrong. And so it becomes to me to have to round up that person and really kind of come at them. The better way to do it is just the opposite. The way Dixie would likely approach me and say, look, my person's got problems, no doubt about it. And I'm not trying to excuse them, but let me explain them to you. And if she does that convincingly with me and persuades me, and gives me the chance, sometimes I'll interview that person and really stress test them and subject them to the kind of interview they're not going to get from the government. They're not even going to get from the committee. But once I'm persuaded, when I've been in that role, I often say, well, company counsel works for me now. Because now when I talk to Bill, I'm going to say, Dixie's convinced me that this person, look, they don't fit into the central picture. And I would say to Anita, if you and I are talking, I'm going to say, look, what Dixie's client did isn't the plain vanilla. I'm not even sure it's the French vanilla, but you guys are out here scooping the rocky road. I don't think you want to be mixing these two up. And so that's up to you. You call it like you see it, but we've reassigned that person. They're not going to have that role anymore at the company, but we think that's the right result, as opposed to those other three that Bill also identified. And when you're done with them, we will destroy them, right? We will put them into bankruptcy if we have to. We will do whatever we need. You know, the severance agreements, everything's already all been cut off. But that's where the company has powers beyond those. And so the idea that someone would use it to influence a story, I mean, look, there are a lot of pretenders who've come into this space. But the folks who do it with litigation in mind, that I am focused on a story and defense at all costs, are doing this the wrong way, because the truth gets out. It always does. And so better to embrace that. Why would I fight with Bill? I should embrace what he's doing. I'm going to give him 10 good ideas. He can call them all his, right? He probably would have thought of them all on his own. But what I want him to have to say is, you know, the company helped us at every turn. And then I, in turn, can say, well, hang on a second, I can't take all the credit. Dixie's person came to me with this, and I wouldn't have found it otherwise. And then we end up with an orchestrated solution that's fantastic. And this has been, at the A level, what's been going on forever. And I will always remember when Jamie Dimon, who was not my client, shook my hand in the middle of the market timing mess when he was the CEO of Bank One. And he said, Phil, I don't know where the hell this goes, but I promise you we're going to do the right thing. And that became the name of the business school case study. Doing the right thing is that each of us talks to the other, usually with company counsel as the hub. And my job is to make everyone else look good. And, you know, like the agents in Argo, I don't need credit. I'm just happy to walk away and everything works out.
Well, speaking of walking away, we only have a few more minutes. If I am the individual counsel for the CFO, I'm going to be very focused on this process that Phil just laid out. I also am going to be very focused on the structure of my severance agreement. And I will want to make sure that the CFO has every opportunity to shape the story here to the extent that's appropriate. But the auditors really are shaping everything in all of this. And whether I'm counsel for the auditors or just interacting with them from another perspective, I think that's the perspective that really will carry the day, because they're not going to sign off on financial statements, on their review or on their audit until they're satisfied. And that's the right thing. That's a really important protection for investors. So we have just a couple of minutes left. What I'd love to do is just go to each of you panelists. And if you were to leave the audience with one important thought, I know, Phil, you've already done this once, so I'll come back to you last. But what is the thought about internal investigations that you would want to make sure the audience today takes away from this panel? Anita, can I start with you? I need you to turn off your mute, though.
Yeah, sorry about that. You know, look, doing an internal investigation, the whole point of doing it properly is as Bill said, is to get to the truth, right? And part of that process of getting to the truth is putting the company in a better position to respond, but also putting the company in a better position vis-a-vis the staff, right? So we can be in a better position to exercise discretion on issues of cooperation. And so I think that, you know, we're going to be looking at cooperation from the perspective of, you know, did ultimately Bill come forward and Phil come forward with a fair representation of what happened? You know, is the company taking accountability for the breakdowns that occurred? You know, did they scope out the investigation correctly? Did they give us the facts, the unvarnished facts? And ultimately, did what they brought to our attention, whether that's a witness we wouldn't have thought about or a corroborating point that's by another witness or a document that would have been very time consuming for us to get on our own, you know, especially when it's beyond our jurisdiction, whether that's documents or a witness, you know, ultimately, did those efforts get us salient facts that allowed us to get to the right result faster? You know, tangibly, you know, were we able to accelerate and complete our investigation with the help of the company, and it allowed us to get to the right result in a more efficient manner? Ultimately, that's the lens through which we're going to be identifying how the company behaves. So I think that, how the company chooses to report, whether they give us a summary, whether there's slides, whether it's written, whether it's, oral, or walking us through the document, ultimately, we want the information and we want it as fast as possible. Like, as I mentioned before, we want the facts so that we can make the judgment calls in terms of supplementing that investigation, redoing an investigation, or doing it on parallel tracks. So, but that's how we're looking at it.
That's great. Thank you. Bill and Phil, you had a lot of opportunities, and I think we've gotten your message, but if you had one short thought, Bill, what would it be?
I'd go back to what I said at the top about the importance of competence. Yeah, and making sure people know what they're doing.
Yeah. And Phil?
I would say, as an add-on to that, picking someone who can help you achieve a result that stands the test of time. The truth doesn't move. It stands the test of time.
And I would just leave you with integrity. I think that's really what, at the end of the day, that's really what's going to matter in an internal investigation. Bruce, I think we are wrapping it up.
Awesome. Thank you, Dixie. Great job. Anita, Bill, Phil, thank you very much for a really interesting session and an interesting way to approach this topic. So terrific. And thank you. All right. Next panel is on financial firms. It's at 4:05. So we'll see you all in 5 minutes.